Well,
I have to have a bottle of muscle relaxant. Okay.
Yeah, I know. My back hurts.
Muscle relaxants.
Stop complaining.
We're at the
Our
age
life's
where we're
pretty
getting
good.
old.
Our life's pretty good. It's
Between the three of us,
particularly
we're like, what, 157 years of age? Or
Maybe
something?
200.
so it's particularly good right now because we have a great case in which a false accuser was convicted and held to account for what is actually a crime.
Imagine that.
Yeah, Michael, you grabbed a hold of this one, so why don't you do the lead-in? But this is great. This is from last year.
Yeah, I've been tracking this one for a while because I've had some chats with the people involved in the case. This is crazy.
We're going to be very careful. We're not going to mention names.
No
because,
names. No names.
People have suffered enough on this, but this is...
Particularly the formerly accused, now the victim of the crime.
Right.
Yeah.
The male person is the actual victim of this crime.
So basically, it's your standard he says, she says domestic, where, of course, she had her ex charged multiple times with criminal harassment, uttering threats, and then failing to comply with his bail. So this guy spent considerable time in jail. I think 6 or 7 days in jail, all told.
I think it's about 4 days.
4 days, okay.
It was the equivalent of 6 in the
Equivalent
end.
of 6 when you do the math.
So there was some sort of a relationship
Yes.
between the accused in this case now.
It's under dispute, actually, because he says they weren't actually in a romantic relationship. They were just intimate a couple of occasions.
So there was some sort of relationship.
Some relationship, yeah.
Between this female and this male. And when whatever that relationship was, broke down, she decided to go to the police and complain about his harassing and criminal behavior. So this poor fellow was charged with 3 separate allegations, and as you said, the first one was what? Criminal harassment?
Yeah.
Which is the equivalent of stalking for people
Right.
who aren't familiar
But
with
there
the
were
term.
a total of 11 reports made, 3 of which led to these separate charges: criminal harassment, uttering threats, and failed to comply with a release order.
She was quite persistent.
Because he kept getting arrested and then getting rearrested,
Yeah,
even
so-
though he was not actually contacting her.
Right.
No, so we got to set up the facts. So on the first one, he was released the same day. The second one, he was spent a night in custody before being released. And then on the third one, which was the failed to comply, he was held for a bail hearing, which was a contested bail hearing. And I believe that one was the one that involved messages that allegedly he sent to her in breach of his release order. So that was about so allegedly, there's so much in this.
I know.
So she alleged that he sent messages from his phone to her in breach of the order and was further type of
And she
harassing
produced
behavior.
messages.
Right. She had
And she
so-called
produced
evidence.
the messages.
This is very important.
Yes.
She produced the messages that came from his phone. Okay?
Yeah.
Came from his phone. This is going to be a good one.
This is...
So this poor guy had to be in custody and have a contested bail hearing. And he got out because he had his girlfriend at the time testify at the hearing.
His actual girlfriend.
His real girlfriend.
His real girlfriend.
Not pretend.
That at the material times that these messages were sent, he had not been in possession of any device capable of sending messages.
Alibi.
So it was...
She's like, not only was he with her, but
Right.
he actually didn't even have a cell phone with him.
Right.
Or
Or an
a
iPad
device
or whatever.
that
Whatever,
could
yeah.
send the messages.
Might have been a condition of his previous release even.
So he was able to get out on bail.
yeah.
Take it from there.
Well, this
What did she do next?
surprisingly led to the police deciding to investigate where these messages came from.
No,
Right.
not right away.
Okay.
No. This gets even better. Okay.
Go. You love this case.
Oh yeah, So after his third charge and release, the complainant, so this female, made further complaints to the police. She alleged more text messages had been sent to her and her sister. The context of these messages suggested that the poor guy was stalking her at her workplace. Now, God bless the police on this one.
Oh, yeah.
Something went off in their head and they go, okay, so they actually did something that police should be doing.
Imagine.
What is that? An investigation.
Investigation.
Let's go directly from the case. What did they do?
They had to get
Production
permission,
order.
a production order to actually find out who the owner of the phone number was.
Well, but that's what you do in an investigation. So the police Take it away.
This is court time, though, and this goes against her in the end. How much resources were spent on this?
They had to get.
But let's lay this out. Like
they got a production order for the records, and not only that, IP address information, and they determined after this investigation that she had actually. I love this. She's something else. She had set up some telecom service called Pinger. Never heard of it. She had set up a new phone number or a number in his name and was sending the messages to herself from him. Like that's pretty.
To make it appear like it was from him.
Specifically got a cell phone number in this poor guy's name through this telecom provider. She constructed these messages and sent them to herself to frame this poor fellow for criminal charges.
And why? Because she felt the police had not adequately responded to her complaints.
That's right. And the police traced the IP addresses back to her mother's residence and a shelter where she had been staying because of alleged complaints of what this guy was allegedly doing.
That is to a level of crazy. She's in a shelter for abuse that wasn't actually taking place when she was actually sending herself the harassing messages.
It is disturbing.
And I think that's important to just stop for a moment and think about how crazy this can get. Because you would think that her presence in a shelter would validate that she was being stalked and abused in some way. Right. But in fact, all of it was fake.
Yeah.
We have to deconstruct this, okay? So the police charge her with public mischief.
Mm-hmm.
And, well, good for her. She admits it.
Yeah.
She fabricated, there's that word, fabricated everything, but did say that she was unhappy with the way the police responded to her other complaints. And as you'll hear later on, Ash is being, does something called a pre-sentence report, was still complaining about his controlling and otherwise harassing behavior. Okay, but she at least admits the falsities of these allegations. So let's think about this, okay? So when once in a blue moon we put something out on social media over Twitter and say, well, we were successful today, a client was exonerated, there was a false allegation, in one case of sexual assault, and I get dumped on by a number of lawyers and other people to say that I'm spreading a myth that there's no such thing as false allegations, that a female would never make an allegation of sexual assault. That was probably just down the road for this complainant to make yet another complaint. And it's not a leap to say, well, they wouldn't lie about sex assault, they'll only lie about every other thing. Right? This was a premeditated, well-planned, constructed, determined effort to ruin this poor man's life. Much like that poor
British case we did.
No, is he a football player or a baseball player in the United States? Is he with the Dodgers?
I think football, no?
Oh my God.
He went on social media because he was specifically targeted. Trevor Bauer.
Right.
Baseball?
Yeah.
Okay. I'm sorry, Trevor. I do follow baseball, but it just slipped my mind. His career was completely blown out, and he'd been specifically targeted because of his wealth at the time and his notoriety and everything else. This is the same.
Well, this guy, financial. You read what happened to that. He explains in his victim impact statement. This is page 5. He suffered financial consequences from lost work for a period of a couple of months. It's a lot of money for the average person this day.
Never mind the emotional
health consequences from the stress, psychological harm, and obviously reputational harm. You don't get that stuff back that easy. And being, as he said, being held in custody during COVID.
He was in custody. And had it not been for his girlfriend at the time to testify, the judge in the sentencing
or give
said,
evidence to the police that that he had an alibi. She didn't have to testify. We didn't go that far, is my understanding. But
in order to get on bail,
testified at his bail hearing.
Testified at his bail hearing because the judge sentencing here said, I can read between the lines, he probably would not have gotten out on bail on this third charge if not for this evidence that's essentially an alibi. So think about that.
Can I read a little segment here?
No, but just wait. Just think about that. What if he didn't have that evidence?
It's rare.
And is detained in custody
for months.
So then she doesn't need to send the other fabricated messages because her goal has been met. is now in jail.
Yeah.
Just think about that for a moment.
There's language in
Why should the police, whenever messages are sent, allegedly harassment or whatever, why should they not be investigated? Why should the police not obtain something more than a goddamn screenshot?
Right.
Or embed it in
which
some
often
occurrence
get
report?
complainants to take. They don't even take the screenshots themselves.
Right. It is so easy now to get a phone number and attribute it to another individual.
There's a bunch of different
You can clone phone numbers. You can create it through other telecoms. You can do all sorts of things.
Apps. There's even apps you can create.
There is an absolute need now not to take at first blush, unless there's a fairly convincing evidence of a real thread of messages where you can honestly say that is a message from the accused. They need to investigate this, because just imagine he didn't have that and he'd be in custody. Yeah. Sorry, go ahead, talk.
Well, the police have the ability to look into these phone numbers where the accused doesn't have the ability as easily to do the same thing. They can if they have the resources, but not everybody does.
Not even.
How would he find out?
How?
It's hard to get a court order for
Just
He would literally have to go get a third-party records application to try and trace the IP address. Good luck
with that. Yeah.
The police get a production order. They have resources. He would not have it.
No way.
Even we would have a challenge to get that.
Yeah.
And it's a good reminder, I think, for the police and for people going to court too, that just because messages are produced, screenshots of the messages are produced, doesn't actually mean that that there's any merit to them.
That's right.
Or that they're real.
Yeah.
Just today, we're arguing about a message that our client allegedly had sent 2-3 years ago. And I'm saying to the Crown, in the midst of the argument that we're having in court, I don't have the text message. Well, it's right here on page 43 of your disclosure. It's in the occurrence report. And I said, and I said very nicely, I realize it's in the occurrence report, but can I please have the actual text message?
With the metadata.
With the metadata, please.
But even so, this is a situation in that case where the complainant was living in the same house and had access to the person's phone. So there's nothing to stop them from sending a message to themselves.
100%. I mean, people, they don't have, they know each other's passwords, or it's not password protected or whatever. And so you can easily go on the phone when somebody's in a shower or whatever and send a message to yourself.
There's some wording in this message, in this decision, that really makes me happy, and I just want to read it out.
Yeah,
okay?
Please do.
Highlight.
Her willingness to manipulate the justice system to serve her own ends has harmed the administration of justice, the community which depends upon it, and every woman who comes forward with a legitimate complaint of intimate partner violence. Parliament has recognized that women in in these contexts are inherently vulnerable. This is the reality, notwithstanding that the accused and convicted may have believed in her own mind at the time that she was justified in her actions. This woman cried wolf. In doing so, she created the risk that her conduct may undermine the credibility of every victim of domestic violence who comes forward in the future with a complaint for investigation to police. That is so important, and this is something that I've mentioned over and over again. When we find evidence of these complainants who have lied and provably lied, and then in this case actually get convicted for making a false report, there needs to be an appropriate reaction by advocates to recognize what that means to their own cause.
Yeah, okay, yeah.
6 months jail.
And the wording in here, I think was perfectly
Well,
enunciated.
as I said, you have to, taking this into consideration, the judge noted, I know I'm being repetitive, these acts were premeditated. They were not the result of a momentary lapse of judgment or sudden passionate impulse, which we see in many cases. These acts were carefully thought out. It took time, effort, and some degree of sophistication to set up this phone line in a name and disguise it in connection to her. And her acts were repeated time and again. They consumed valuable police and court resources. The police and courts are always strapped for resources and have been under particular strain during the pandemic. On and on and on. Yeah. And the point that you raise is very important. Yeah. This does harm those who come forward with legitimate allegations. But leaving that aside.
Where's the rape myth is my question. Where's the rape myth in this case? She did lie. And we would be accused of engaging in rape myths for saying that women lie about rape.
Yeah.
You know? And that, we're saying she's a scorned lover. We've had that before. We were told that we couldn't argue in defense that somebody was a scorned lover because that's a rape myth. She was a scorned lover, wannabe lover.
Right.
Who then created her own stalking scenario. All of that, I'm sure they could come up with about 3 or 4 different rape myths that we're supposedly engaging in, when in fact, not only did she do it, she pled guilty to it because it happens.
We have to walk around with this case in hand. Anytime we go to court and they want to say it's a myth, and we're just going to go, sorry, it happens. Here it is. Hand it up.
And the other cases, the judge references here, there's false rape allegations against a police officer. I think we covered this case.
We did, but let's
yeah,
because let's deconstruct that. Let's go into that one too for a moment.
So that one was an Alberta Court of Appeal case, Ambrose, 2000, ABCA 264. And basically, again, I love the quote, offenses against the administration of justice have great potential to be serious because they pervert the whole regulating system for behavior of everyone in Canada. So the majority here held that a jail sentence, as opposed to a conditional sentence, was needed on the facts to achieve deterrence and denunciation. A total sentence of 2 years with some reduction for pre-custody time was imposed for a false allegation of rape against a police officer. So 2 years, not insubstantial.
Yeah, so again, it happens. And we go back to an episode, people lie. People lie.
But also, we've kind of tried to make people aware of, because it's very common when people are falsely accused, the first thing that's on their mind is what happens to her.
Yeah.
Right? And the reality is this is a very rare case. That
This is extremely rare.
It is.
Normally nothing happens to them. And in this particular case, there was solid, hard evidence.
We were able to establish in a case we did somebody falsified a marriage certificate, which is an offense under the Marriage Act.
No interest in charging.
They paid an officiant to sign a false certificate. They had
to use that
they
certificate.
had a brother and a 17-year-old sign. It was a f***ing fraud.
Yeah, and that was designed in order to help her get money in family court when she wasn't entitled to it.
Because if you're legally married, then you might have a shot at the assets.
Right.
We proved that. It was found by the judge.
To have been falsified.
And nothing happened. Nothing happened to her.
So that's one of the things, I think, to not get people too excited about this case, even though it's exciting that there is some great language from the judge and a great finding, and great police work that was done in this particular case, that at the same time that they shouldn't hold their hopes too high, that there is a fairly serious mandate to prosecute cases, and the evidence has to be extremely strong.
Yeah, but this evidence wasn't that hard to get. That's the frustrating part. This isn't rocket science. This isn't DNA. This isn't forensic.
If you want to, in a fraud case, put in banking records in part of the prosecution, as a victim of fraud, you have to provide the police with actual banking records, verifiable banking records. And in order to prove the case, the police will often serve production orders on banks, on the accused account, and sometimes on the victim's account in order to get the full history, and they'll do other investigations, and what they're going to put forward is a proper forensic review of everything that happened. In fact, you have very talented police officers who are basically like forensic investigators. But in a case of sexual assault or domestic violence, where sentences are increasing more and more, where sentences can eclipse that in a fraud case. $1 million fraud, if it's a breach of trust, may get you a year or 2 in jail. Well, sex assault can get you 3 to 5,
right,
depending upon the facts, or more. Mm-hmm. But there is not an effort made to secure the actual messages.
When it's available, I mean, it's pretty clear.
It's available.
It's available. This is not
the whole charge was based on messages, and there was originally no investigation into verifying the source of them.
I get that, trying to execute, a production order on WhatsApp or, some of these other
Offshore ones.
Yeah,
It's
it
hard.
is not easy.
No.
But we have in a lot of our cases that these are messages on the cell phone.
Local, yeah.
Yeah.
I think we can't expect from this that in other cases where there will be pretty solid evidence that the complainant has fabricated or lied, that in fact they'll be investigated and charged. But I hope something comes from this, that there's cause for pause. Yeah, people make false allegations. There are reasons for that. And we got to come back to what you said. We've had it tried to be shoved down our throat that a scorned woman will not lie about offenses.
It's a myth, I hear.
It's a myth. That it's a myth that they lie about sex assault. In this case, yes, it's domestic related, but it's pretty bad. It shouldn't be that hard that we just say it's a criminal justice system. We have due process. We can't #believe. We have to get evidence, and then we have to let the system play out. And once you have the evidence, then you can go forward. No problem.
This goes back to as well what we like to try and keep repeating, which is that the evidence of a complainant, yeah, okay, you can take it seriously, although it should be investigated, but you also should take the evidence of an accused seriously. That you can't just, and that seems to be the thing, is like, we encounter this all the time. It doesn't matter what he's saying because she said blah.
Investigation stops, yeah.
You know, and even going into trial, we get that attitude. And, you know, the accused deserves a voice. And also we have to remember, you know, it is traumatizing for people who really experience these types of crimes. But there's another type of crime, and it's very traumatic for an accused person to be falsely accused.
It's bad for everybody. Yeah. Real victims suffer real harm. That includes people who are falsely accused. Right. And we've said this all the time. When somebody's charged, it's life-altering. In this case, this gentleman also had been in a divorce. Mm-hmm. So his former ex tried to use these allegations against him in the family court. We see that all the time, right?
It's the playbook.
But, you know, when we just relate this for a moment to cases that we handle, there are so many motives to fabricate that we uncover.
Some of them including that the complainant doesn't even know why she lied.
Right.
That's one of the leading reasons. So
and good evidence that we're able to uncover and prove at court through cross-examination and also through our client. So your point about that there has to be value placed in accused evidence, I think is extremely important. And I think it bears a little bit of emphasis here. In cases that we have, and when we're bringing these motions, the 276, 278 motions, sometimes we're faced with arguments, and sometimes from the bench, that, well, the accused evidence is the accused evidence. No. Some evidence that we want to have admitted on these applications is relevant to the coherence of our client's testimony. Mm-hmm. That must be given weight. You don't just, it's the accused evidence. It's almost a presumption of guilt. We've always said there is, but it's palpable.
Same thing with, the accused privacy rights.
Right.
The complainant could take the exact same text messages and put them into evidence through the Crown without any application or any question. But the exact same messages, even though they might match ones that are provided by the complainant, but there's a few missing ones that they want to fill in, right? We have to get permission to use them in court, and they're presumptively inadmissible if you're the accused person. So the accused person's privacy rights don't matter when the Crown has the evidence. But the complainant's privacy rights, let's make sure we go to stage 2 and give them a lawyer and all this other stuff for free.
Or in like the case you had, when there's messages that actually can be helpful, that the Crown has and they disclose, then they decide, maybe we shouldn't have given out because we weren't able to waive the privacy interest. So give them back and let's argue it out on a motion.
Changed our mind.
Yeah, I mean, it is, you know, and again, you know, there's lots of Crown attorneys that we deal with who do a very good job and are very honorable.
Yeah.
And frankly have made our applications, you know, much easier.
They generally do their job, which is to seek the truth, not to seek conviction.
Right. But there is this overwhelming presumption. And there is this dismissal of really the importance of the accused evidence and that an accused can be innocent. It's just there. It's palpable. Because this poor man could have been held in custody if he didn't have that evidence.
For a lot longer, because he was held in custody.
And this may never have been discovered.
Right.
He might have been there, have to bring a bail review 90 days later, maybe get out because he's done enough time for the alleged offenses. who knows what would have happened? But if convicted, this would have been a wrongful conviction, a fraud perpetrated on the court that would never be discovered. Can we imagine how many other times this has not been caught because there was not investigations into what the evidence was? And that's why when we have cases that are he said, she said, are so challenging, because those are cases where the standard of reasonable doubt has got to be really high, right? It doesn't have to be 100% perfection, but pretty darn close. What is that, Star?
Yeah. It's got to be up
Regina
there.
versus Star, right? You know, it's got to be pretty high, and they got to hold on to that. And that's why this WD analysis absolutely cannot be watered down by that decision, JJRD. I hate that case, and when people bring it up to me, it's just garbage. It's absolute garbage, because I know in other jurisdictions like British Columbia, on a WD analysis, they almost have a fourth prong, which is like, you know...
We're going to have to just explain for a moment. WD...
You gotta,
sorry.
You got to explain both cases.
WD...
Just checking my pulse.
Yeah.
WD sets a standard to make sure that the reasonable doubt standard is upheld. There's basically, it's three-pronged in the way it was originally formulated. Well, there's been some improvements, I think, by Pacheco.
Your favorite judge, just...
I know.
Yeah.
But number one
and
is,
he wrote an excellent article.
if you believe the accused evidence, then you must acquit. If you don't believe the accused evidence, but it raises a reasonable doubt, then you must acquit. If you don't believe the accused and it doesn't raise a reasonable doubt, you still have to look at the whole of the evidence to make sure that the Crown met the burden of proof.
And here's a fourth one in BC. They actually build it into their judgments. If you can't decide what happened, you must acquit.
Yes, I know that's...
So just think about that for a
Pacheco
moment.
kind of built that in,
Yeah.
too.
He did, because
Can I
he
say
said
his
it's
name
not...
again? Pacheco.
Yeah,
It's not a
fan club.
contest. It's not a contest where you have to determine one or the other. But I can tell you, not everybody, not every judge will adhere to that. And when I hear this JJRD case, it drives me insane.
Explain.
So JJRD is a case from our Court of Appeal from 2014.
Ontario Court of Appeal.
You'll thank
Ontario
me
Court of
later,
Appeal,
folks.
2014, where basically there was nothing specifically wrong with the accused evidence.
It was plausible.
It was plausible. It was reasonable. They weren't necessarily shaken on cross-examination. There was not really internal inconsistencies. But the complainant's evidence was so compelling, and in that case there was a diary, which it was a diary, right?
Had some, corroborating evidence,
Had some
circumstantial.
circumstantial evidence that supported it. The trial judge was able to accept the evidence of the complainant over that of the accused because it was so compelling. Yes. So that has been bastardized now into not simply meaning, well, there was some corroboration. So therefore, there was some corroboration that really assisted with preferring this evidence. That should never be used.
How it's being argued is they're saying that you don't need corroborating evidence. You can simply just convict somebody because you accept the complainant's testimony. And that is precisely the thing they're not permitted to do.
And that's what I heard in a case we
hear it all the time.
Just last week, where the argument was, well, Mr. Neuberger, I thought that too, that there had to be something really compelling about the evidence, but I don't think that's the case anymore. And I'm like, well, what decision are you referring to?
It's been actually, because it has been misused, the JJRD case, there's actually been a number of decisions to try and dial that back to make sure the reasonable doubt stays in place.
Yeah, so
you just cannot simply pick between testimony.
From now on, when we're doing these written submissions, we didn't put in the whole litany. I'm putting in the whole litany of all of these subsequent cases that water down JJRD. But it's still out there like COVID, like it's not going away. And it's, we're kind of immune to it. We can live with it. It's fine. We can work around it. It's okay. Everything's okay. But it comes back to bite you in the ass every so often. It should be just thrown away.
To make it clear, the idea of that you would go and just choose between testimony and a he said, she said case goes directly against, the reasonable doubt and burden of proof. It goes against the burden of proof that this is not a balance of probabilities. You can't just simply choose between testimony.
Eeny, meeny, miny, moe.
So in JJRD, the reasons were very well articulated, and that's why the Court of Appeal upheld it.
Well, it's Doherty, I think, who's lead on that, and he's a brilliant writer. And I don't disagree with why he upheld the judge's decision. What I disagree with is the use of that decision later on, where you don't have something compelling about the case, something else as an anchor to hang your hat on, that this is why this evidence is believable beyond a reasonable doubt.
Well, we've kind of veered away from our original topic, but I think...
but I'll bring it back for 1 second. That's how dangerous this all is.
I know.
So when you accept the fact, when we as a system accept the fact that people do lie, men and women, that they may have other reasons to bring an accusation which is false. Then you step back and you go, okay, so we have to be objective and do this analysis and give great weight to both sides and analyze it carefully. We don't just say, that's the accused evidence and, there's uneven scrutiny. We can't do that. If we can get from this, because of the dangers in a he said, she said, if we can get from this, let's be cautious. Let's come back a little bit more to WD analysis and let's really have the rigor necessary to analyze these cases. Then I think this is important and it's helpful. But if it's ignored...
Well, I think it's a good sort of like variation off where we started too, because it is so rare for complainants to be charged and convicted of making a false complaint. And it's really important for people to remember these cases are not simple to defend. So where we went to from there is just basically, just because somebody got charged and convicted of making a false complaint, do not go into this thinking, oh, well, she's lying, therefore it's going to be easy. It is not easy.
We are taking in appeals where it's horrific. Like,
scary.
People think, oh, it's okay. Like, I'm innocent, so
Yeah.
They
the
got no
truth
proof.
will set me free.
Yeah.
And then the jail cell is locked on you.
Joseph Neuberger will set you free.
All right. I could go on and on and on. Good night. By the way,
And Michael Berry will set you free because you're quite good as well.
to our viewers, thank you very much for viewing and sending your questions and your comments. So, what's the pillow say? Don't forget to like, comment, subscribe, and
share.
Good night. Thank you, everybody.
Good night.